So April. Service is awaited. Today is 23rd. Another approximately a week. If it come, it will be late. Keep it. Or can it be little earlier? Say 30th. Service report upon respond number 2 stated to be awaited. However, case there is receipt shall be retained. List on 30th March. 3 and 4. Personal difficult. 27. This. Okay. Your message. Okay. Learned. No problem. Malacca Learned Council submits that seeks an adjournment of the matter due to some personal difficulty of the leading counsel and prays for listing it on 27th. Mr. Yogun Adhar Learned Standing Counsel ED submits that the requisite instructions have been received in the meantime. List the matter on 27-2. Sorry, 27-3. Yes. Item 1. Pardon? Okay. CD not received, issue reminder. Interim bail shall continue till the next date of listing. List the matter on when? After the or yeah. Depends. You can suggest a date. Only 1 week. Then we have actually the last week before Bihu, this time will be truncated, I think, because of the election date, right? Only 3 days, I think, we'll have. No, let it be next week. Let it be next week. 2nd April, is it okay for you? 2-4. Withdraw this matter. Your good name, please. Your good name, please. Mr. H. Das, Learned Counsel, appearing on behalf of the lead counsel S.C. Das, submits that they have instructions to seek withdrawal of this petition. Prayer is allowed. The bail petition is disposed of upon withdrawal. Okay. Any more mention? Yes. Item number 8. 1-3. Okay. Any preferred date? You for the addition. Any interim order? No. Learned Counsel. 6 an adjournment. Item 13. Ground of the leading counsel being out of station. No interim order. So, you check it. So we'll list it after Bihu vacation. Okay. List the matter after the Bihu vacation on a date to be fixed by the registry. Okay.
Bill hearing B is 1718.
Bail hearing. Get on line. We had heard, no, this one? Oh, yes. Okay, I remember. It has been corrected in the meantime. Okay. Hmm. Otherwise, commercial quantity, right? Arrested on 7/4/20. Not started here. Arrested on. Mr. Chaudhary is not coming. He'll be appearing, Mr. Chaudhary. Yeah, Mr. Chaudhary will appear. Mr. RKD Chaudhary will appear. Should we wait for him then? Should we wait for him? We can wait for a while. In the meantime, I can finish off this ABs. ABs get the details.
Item number 2.
It's your matter. If you want C. Heroin. Hmm. 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 Indicated, proclaimed absconder cannot be declared under 82 CRPC, cannot be declared, but the police indicates
Why and how what is our role? What role I have played? Whether I have a particular, I have a dinner, or I have that is okay. The part is specific. The help and yeah, we get what that we like that.
Mhm.
That's why I put the different case for all I put on it. Yeah, I have that here
Show me. Show me.
whether I made it or I put it. But the main is that I I'm very like I pay for the tax on the ultimately for it not to take what else I but that I pay for the after that it's like wait
Oh.
that no that
Hmm. Here, co-accused also not implicated. Oh, in that case, we'll have to see that.
I definitely right.
Okay, you must have gone through the scan copy. Yes. Just a minute. Just a minute. Some merit we have to go into because 21 C is there. And so 37 determination has to be made, but learned counsel that there is no materials against him except for mentioning as abscond. So that aspect we have to see. Okay. Whatever is there, it's there. There. OAQ statement is there. No. Police does not declare proclaim absconder. Court. Police indicates in the charge sheet in red. Because declaring as proclaimed absconder has its consequences. Property may be forfeited and all these things will not follow. Only a court order and the previous, I don't know what, I don't remember what is the new section, 82 shares, as you know, as we all know. Hmm. PNA is issued. PNA. Because I think there is a judgment of the Supreme Court that the proclamation is there. I referred to it in one case. Hmm. Hmm. Supreme Court judgment. We can take out. No, that is clear. You know, when PNA is issued, if I whatever remember correctly, if PNA is issued, then anticipatory bail is barred. But what? Sorry, yes, sorry. If the proclaimed absconder is issued after examining of PNA report, EO proclaimed absconder declared, then anticipatory bail is barred as per the law laid down by Supreme Court. But what will happen if the process is there? Not yet declared proclaimed absconder, but process has started, PNA is issued. So I clearly remember in one case, this question had come up, and one of the learned counsels, I think prosecution, that or informant side, somebody had shown a judgment where even with regard to process, that PNA is pending, and this bar seems to that we have to cross check. Otherwise, if he wants to appear and face the trial, that's good. And as far as materials are concerned, what are the materials? Only the statement of co-accused. So anyway, but if this is the password, that order, that decision I had used, I had gone through and I passed an order on this subject, but I don't remember the case law. You can find out. Oh, they declared as proclaimed absconder. Oh, then it will apply. Then we need not go, but still you look up that law. Sometime we'll need it, because in the process is also on. This bar might be there. That's what it was said. It was said like that. But as far as if somebody is formally declared, then so it is applicable. No, EO was examined. No, EO was examined by the court. It was not, proclamations could not be served, and it was put up in a conspicuous part. AB, I think the remedy of AB will not be there, but he may be able to have take recourse to revision or 482, something of that sort. But AB would be, I think, proclaimed absconder. No, that will be contrary to that will be per inquiry otherwise. No, but the thing is that proclaimed absconder, after declaring proclaimed absconder. No. Declaring absconder by the police is not a problem, because police does not have the power, as you rightly say. That is the police only indicates for their own convenience. It is the indicates that he's not being found. But legal term of absconder would be applicable only if it is declared by the court under 82. Can you give me this decision? I have to check up. Anyway, if they are declared as proclaimed absconders, then there seems to be no, sir. As I said, he is willing to appear. If the only material is the statement of co-accused, and is willing to face trial. That is that is good, actually. That is good, positive. The only thing is that there seems to be a legal bar. Legal bar in terms of law laid down by Apex Court. So all of us we have to abide by that, isn't it? This is the order you're talking about, 11.6. Can you give me the full citation? I'll complete the dictation inside, but I'll give it here. 2014 to SCC. Pradeep Sharma. 24. Name, can you? Okay. Mizoram case. I'll go through this part. I'll conclude it. I'll give the dictation. Otherwise, I'm making my viewpoint clear. That materials are, and then he wants to participate. That's okay. But the thing is that what to do about the legal, what to do about the legal bar. That is the problem. Anyway, third step. Have a seat. SC Biswas, Learned Counsel for the petitioner, and K. Boyso, learned additional fee for the state. Invoking 482 BNS, the petitioner is seeking anticipatory bail in connection with Tholai PS case number 80 of 24 under section 21C of NDPS Act, which after completion of investigation resulted in a charge sheet in which the charge sheet against one Rajibul Islam Laskar and three others, and all these three other persons, which includes the present petitioner Julu Haq Laskar, have been indicated as absconders by the investigating agency. The charge sheet has been filed under section 21C of the NDPS Act. The learned counsel, drawing attention to para 17 of the charge sheet, submits that apart from mentioning that the three purportedly absconding persons, including the petitioner, are not to be found, there is no other implicating narration in that charge sheet. The statement of co-accused is there. It's there. There's a yes, sir. That you'll get. But we'll stop. The learned counsel submits that as the investigation is completed and the petitioner is willing to face the trial, and without any narration of any adverse materials, the police is not justified in just mentioning him as an absconder. The scan TCR has been received. The learned additional PP has drawn my attention to the order dated 11/6/2025 passed by the learned trial court in NDPS case number 119 of 24, which was registered after the submission of the charge sheet. I perused the said order. In para 4, it appears, it is revealed from that order that after examining the executing officer pursuant to PNA report, the learned trial court was pleased to declare Riazul Haq Laskar, Julu Haq Laskar, Julu Haq Laskar, the petitioner, and two others as proclaimed absconders. And case was filed against them, apart from keeping the NBWA pending the concerned police station. The learned additional PP, referring to the decision of State of Madhya Pradesh versus Pradeep Sharma, reported in 2014 to SCC 171, and another decision 2024 SCC online SC 642 submits that in view of the law laid down by the Honorable Supreme Court in these cases, granting of anticipatory bail in the context of the petitioner being declared a proclaimed absconder by the court would be barred. I perused the materials and considered the submissions and also the case law cited at the bar. I'll have to go through the decision once. Five. Okay.
05.
Cattle. That is okay, but the thing is that if there is a secret chamber, so that is slightly unlikely that the driver and handyman will do it without the knowledge of the, the owner. It's not so easy. Not impossible. Nothing is impossible, but not easy generally. The cattle has been released. Where is the cattle? The cattle have been given in Jima. Vehicle has been given in, and the cattle. Gosala. Page. Okay, I'll see. Yes. Yes, seems so. So, no problem. Third, Mr. Izet Ahmed, learned counsel for the petitioner and K. Boyso, learned additional people. The invoking 482, 483. No, this is the anticipatory bill. No. 482 BNSS. The petitioner, Asmat Ali, is seeking anticipatory bail in connection with Golagon space case number 25 of 2026 under so and so section. Full stop. The aforesaid case was registered based on an FIR on dated 5/2/26 lodged by police official. The allegation that on that day in the morning, while being on duty, one truck bearing registration number AS25FC 4796 coming from West Bengal towards Dhubri was intercepted. And upon search, 12 numbers of cattle uh, in uh, unhealthy conditions were found, and it is suspected that they were being carried for transportation to Assam or Bangladesh. Two persons were arrested from the vehicle, being the driver and owner. Sorry, the driver and handyman of the vehicle. And subsequently, the learned court below was pleased to release them on bail. The copy of the said bail order has been produced before the court. The present petitioner is not named in the FIR and is stated to be the owner of the vehicle. And it is submitted that, and submitting the relevant order in this regard passed by the learned trial court, it is submitted that on 26/2/2026, JIMA of the vehicle was given in favor of the petitioner. The case diary has been received along with a bail objection. The IO has objected to the bail, and the learned additional PP supports the bail objection. I perused the statements of the driver and handyman who were arrested and subsequently released. Uh, uh, and they have not really implicated the petitioner. In fact, one of them, Saidul Islam, stated that he carried the cattle due to his greed for money. Full stop. In my considered view, seen the progress of investigation, in my considered view, subject to suitable conditions, if bail is allowed, the investigation may not be prejudiced. In such view of the matter, it is directed that in the event of 30,000 with one security, subject to the satisfaction of the arresting authority, and subject to the condition which will cooperate with remaining investigation, not hamper or temper activities, shall not commit any illegal activities, including any activities violative of the Cattle Act and prevention of cruelty to Animals Act. Return the case diary, bail petition stands disposed of.
Item number 8, counter item.
Kindly, we have some. It's for suspension of sentence. Suspension of sentence. You are for the informant, right? Amicus, legal aid counsel, right? Okay, that's all. You are appearing for the prosecution, also. You are appearing for the prosecution. Rigorous imprisonment for 5 years. Have you filed any objection? You filed an objection. Should I take it up today or appear for this? You'll be getting a paper book also, I guess. Paper book has been directed. But paper book is always very useful, very useful, very, very useful. We should invest in paper books, civil, criminal, everything. That is true, but what do we do about this? This has to be disposed of. I because it's a 20, Madam, it's a 25 appeal, so it will be jumping the queue if we take up the hearing. So paper, I have to pass an order in the main appeal. No, this IA, if you have some difficulty, we can take it up any other day this week. This week, tomorrow also I'll be having single bench. Yes. No, I think I'll be having single bench each of these days. So it can be just a minute. And Sarkar. And Sarkar. Sir Raki and Sarkar Land Council. Apple additional people and Madam of the post. The appeal has been admitted. I have not seen the issue notice. Only notice has been issued. It has not been admitted. So we should the appeal being a statutory first appeal in criminal law is admitted for hearing. Notices have already been served, and both the prosecution and the informant have entered the prosecution, uh, and the prosecution has, sorry, copies have been furnished to the prosecution as well as to the learned legal aid counsel for the informant. Full stop. The original TCR has been received. Should we ask a paper book? The registry may prepare a paper book in sufficient sets. Whereafter the matter can be taken up for hearing. List the matter in the orders column on so and so. It has to be together. On 27. No, this will be, this will take some time, right? .30. IA full stop. In this, IA seeking suspension of sentence and bail. Full stop. The learned legal aid counsel appearing for the respond number 2 seek some accommodation. And praise for listing the matter on Friday. Which oh 330 list on 30. This I seek some guidance on you. This main appeal has to be also fixed together, right? Because obviously the paperwork won't be ready. It will take some time. But I am fixing it on 30th. Yes. Orders columns. Because it will look unreasonable, fixing it on 30th for paper book.
Yes.
In the main, you write this thing that the connected IA has been fixed for hearing on 30th. Accordingly, this appeal may also be listed. Wait.
Number 9.
Itu potay dito. Appeal. Appeal. Appeal to potay. Be not criminal appeal. Put up. This case is State Bank of India. But what is the Gujarat part of the matter? DGP Gujarat and SP Jamnagar. Just a minute. Just a minute. Some report was directed to be with a positive time. Hmm. He lost his mobile phone in the train. Then what happened? How did he become? He's a victim? Frozen. Just a minute. The police wrote a letter regarding defreezing this account. I, I have not fully understood actually. What, uh, yes. Uh, mm, mm, mm. Acha, GD 54 is not there. There's no GD 54 been found in connection with this. That means this GD could be of Gujarat or what? To be of the Silchar. Mm. Mm. I'll come. Further source, what? Yeah, 3, 4, and 5. 5. Yes. Yeah, actually, today it has come for this report perhaps and the order and service of notice. It's pending for. Why three service should be complete? It's from State Bank of India. Yes. No, because service has to be completed, sir. Isn't it? Service has to be completed since you have made party. This is page 28. Acha, acha. Okay. Hmm. Have you got a copy of this? Page 41. This is the letter I was referring to. Police Inspector Jamnagar. Will it be possible on your part from police here to verify this document? Should I? Should he then? Because they have written that on a certain complaint this was freezed, but now it is not necessary. Now it is not necessary, and that is a spray that it should be defreezed. But but service should also have been complete actually. Service should have been complete also. Hmm. CJM has passed an order rejecting 30. I think at this stage, I'll see that order, but I think it will be better to just verify this. IO in this report account number. But the IO has submitted a report. Slightly confusing, actually. The IO has submitted a report here, on the basis of which, and on the basis of which CJM Kasar has passed an order rejecting the. Third, the Learned Council and K. Bush Learned additional people. We're invoking 528 BNSS, read with 529, 528, 529. The petitioner is seeking interference with order dated 5/8/2025, passed by learned CGM Kasar, whereby the prayer of the petitioner for defreezing of his account number 112-846-80160 in the State Bank of India. Which branch? Silchar branch was rejected. As reflected in that order dated 5/8/25, the said account was frozen due to an online complaint registered on cybercrime platform by Gujarat Police within bracket Jamnagar. Uh, on the basis of a complaint by one Babu Sena Singha. Full stop. A report was called for by the prosecution with regard to the GD number 54 of 25, Silchar PS GD number 54 of 25 mentioned in the impugn order. However, wireless communication has been received and placed before the court, wherein it is stated that no such GD entry has been found in connection with the instant criminal petition. 5 respondents have been impleaded. Respond number service with regard to respond number 3, 4, and 5 is not yet completed. By way of an additional affidavit, the petitioner has brought on record a letter dated 31/12/25, purportedly written by police inspector of police, Bedi Marine Police Station, Jamnagar, stating that investigation is completed and no objectionable matter has been found regarding that account, and therefore there is no need to keep it as debit freeze. Full stop. The prosecution shall be furnished a copy of this document, and the prosecution would take steps to verify the said document, if necessary, in communication with Jamnagar Police, State of Gujarat. Okay, that you can do. Let us be sure about the position. This is the matter on. Suggest. Take it. Hmm? Yeah, 21, 21, 21, 4. 21, 4. That NCB matter is not really. There. Hmm. Okay. Josh. Yeah, you are for the accused. Notice was issued, right? No, the latest office note, 9/3/26. It is awaited. Will not dispose of the IA But who's appearing for the opposite side? Notice is complete. Notice is not complete. I think we should wait for the notice. What do you say? For the IA also, then we can stay if necessary in the next date. Next date of listing. Yeah, it is. We can wait for some more time. Take instruction. That it can be done. That can be done. That can be done. The case record is received. Scan record is received. My friend. Can it's all right. It will be. Oh, it has come. It has come. It is there. Sar Chaudhary, Learned Counsel. Additional bill. Petitioner is seeking quashment of the Dhubri PS case number 74 of 25, as well as the charge sheet number 192 of 25, dated 16/5/25, filed after completion of investigation in that case. As per office note dated 9/3/26, service report is still awaited. The prosecution can take instructions regarding the service upon respond number 2 to the concerned police station. The IA has been filed for suspension, for stay of the impugn order pending adjudication of this criminal petition seeking quashing of FIR and charge sheet of Dhubri PS case number so and so. Notice service report upon respond number 2 is awaited. The prosecution take instructions regarding the same. Scan TCR is available in both of liquidity. Scan TCR is available. Huh? True. This is not essential, but still, that's true. 30. Can you take instructions? We'll fix it on 26. No? On that day, we'll take it up. No. Regarding IA, we'll take up the IA on 26. In the meantime, if we can get some instructions. Right?
Number 11.
Sterile, this I think let me washing of. It's an investigation stage. Charge sheet is submitted. Okay. So if at the time of filing your FIR, that is always better from the point of view of procedure. At the time of filing, if charge sheet was not submitted, you can update your prayer by filing an additional affidavit. But you are settling it most probably. But otherwise, if it proceeds on merits, better to update your prayer by filing an additional affidavit. Right? Learned Counsel, good name. NZ Sarkar, Learned Counsel appears on behalf of the respond number 2 and 6 sometime to file. You'll file some written reply and take some time to take instructions. It is submitted by the Learned Petitioner Counsel that the parties are also working at a settlement. Perhaps the parties are also working at a settlement. This is the matter on after vacation. We leave aside the last week. Huh? Anyway, we have a truncated week. Only 3 days will be there. 11th, 9th will be a holiday. 10th also probably. So, 2nd, 3rd is a holiday again, right? Second. Otherwise, we don't have very many days now. Okay.
Number 12.
Just a minute. Your matter, sir. I think you've been waiting. So should we fix it tomorrow? Yeah, should we fix it tomorrow? Uh, give it. I'll- You can give me the citation. She will take it up. Right. Look. Okay. Learn. Then we could have kept it for tomorrow, perhaps, or third. Did we? Keep it for tomorrow. No, this was there in Asha Dubey. Asha Dubey is, Asha Dubey, yes, Asha Dubey address. Asha Dubey. That was the case I had discussed. This you keep in the record. You need to Silchar case. Upon praising of Asha Dubey. Yes. I remember this is the decision we had discussed. No, no, definitely. That is, as I say, that's good. The only thing is that legal bar, if it is there, that has to be seen. Pradeep Sharma, Asha Dubey will see. Asha Dubey citation is there. It is there. Now I remember the name. Sabalai. Okay. No, this is possible. Mr. Boyso, I'm not keeping it for tomorrow. I'll dispose it off. Okay. I remember now. That was the case of Asha Dubey in exceptional circumstances. Possible, but in exceptional circumstances. So this it to 17, 18 tomorrow. It's tomorrow. Mhm. Mhm. Positive time. Yes, please. Dismiss for default. Oh, that's too bad. Mhm. No, no, the. Mhm. Mhm. You will, we'll see that order. You have that order. Another day, you place it before me on the next day. On the next day. And since it's a complaint case, I think service should be, we should wait for the service. I think. That was disposed of without service on the first. Dismissal for default is it can be perhaps, but since it's a complaint case anyway, since you have taken steps, let us wait one more day, and on that day you show me the decision also, right? Service report is awaited with regards to the respondent complainant. Learned counsel submits that with regard to another very similar matter. The revision preferred against dismissal for default was allowed by the court at the on the first day itself. The learned counsel may place the decision on next day. In the meantime, await service report upon the respond. I'll give you a date. The scan copy has been received. Scan TCR has been received. Take it. I think we have very few days. We can. Will it be possible before vacation or after that? 21, 21 for Tuesday after reopening.
Okay.
private respondent, informant, FOXO. It's the sentence. 5 years. As per office note dated 18/3/2026. I think it is. Is it sub acceptance notice? What is this? Acceptance notice has been received and flag, like a flag AN. No. No, steps is common. Steps has been taken on. No, not yet, sir. Not yet, sir. Not yet, sir. Service report awaited with regard to the respondent number 2 informing, right? This is the matter. Four is, I think, okay. 4 is the open setting. 2, 2, 4. Second matter. Wait, I also have same order. TCR is, we should call for the TCR, I think. Should call for the TCR also. On the next date. On the next date, we'll call for this. Oh, the TCR may be necessary for deciding the IA. Yes. Call for the TCR of so and so asylum from the learned trial court. That will be necessary. No, this is disposed of appeal original TCR. We'll dispose of the IA after perusing, analyzing, and thereafter we can direct preparation of paper.
15.
Right. Not yet admitted, I think. Not yet admitted. Okay. Mr. Mr. Go, Land Council submits that the matter may not yet admitted and may come for admission. This is the matter in the admission column on when do you want it? So we can add, after admitting us also we can issue the notice. Before admission. Issue, you have received copy? The respondent number 1 prosecution has received copy. Steps of notice may be taken upon the respondent number 2 inform to the office of the public prosecutor and to be executed by the concerned police station. Yes. Here also we can issue notice. On the I also we can issue notice. List the matter on. You can suggest after view 22/4.
16.
Yeah, Mhm. Yeah. Any private respondent is there. She has to be heard. Hmm? Complaint, she has to be heard. Oh, yes, it's responded. The notice has been sent. Sorry. Let me see the office note. I don't see any office note. Can you take instructions regarding the service or we'll wait? Huh? Oh, no, steps of notice has not yet been taken. As per office note dated 19/3, steps of notice upon respond number 2 has not yet been taken. The petitioner side shall please take steps, okay? On respond number 2, the petitioner side shall take steps of notice by speed post upon respond number 2, okay? And the case diaries have been received. With the case diaries, investigation is going on, no? 2 CDs. But taking of steps, yeah, no, because criminal case, it may not be proper to, direct Dusty also, isn't it? Dusty may not be proper. You take by speed post. Take by speed post. If we fix it immediately after BU, then you send back the case diary. 26 to service will not be complete. Will not be complete. We can fix it on 7 or 8. 7 or 8 last day. Till then you can read it. Let's fix it on 6. Case diaries may be written. Yes. 80 and 60. 80 and what the CDs and maybe retain the case record. If custody of the case record. Least on, but even 6 is tight. But you take by speed post, then maybe. 90. What is the sentence? 10. Oh, NCB. Today we are to. Oh, no, let us, we'll fix it day after tomorrow. He's probably left or something. He may be. Yeah, he could not appear in the other matter also. Only two things, Mr. Manam. The thing is that, as you know, after it's not a recent decision in that Hira Singh, the judgment of Hira Singh. So the Hira Singh judgment has said that for suspension of sentence also, you have to, take into account 37. Yeah. 37. But if you complete more than half of the sentence, then you should be released. That will prevail over this one. That is the only issue. No, not recent, because that was, that is the Hila Singh was earlier. It was in the backdrop of they had removed suspension of sentence, remission, everything was removed. Then the court said that all these will be unconstitutional. So remission is still not there. There's no remission for NDPS. And as far as suspension of sentence, we said yes, you can suspend sentence, but you have to subject to the application of 37. This was commercial quantity or intermediate commercial quantity? So that point we have to discuss. We have to discuss that point. Our point is, that point that we have to discuss is whether, and that, that 436, let us go by the earlier section only, that 436 A30 CRPC, whether that will prevail over this provision. No. Sure. No, okay, so that will help. Okay. So anytime this week, any Thursday? Okay. Mm. First 26. Regarding the Hira Singh interpretation, I have one doubt in my mind. Maybe I want, because I am not clear about one thing. Is that 37 thing which has to be seen for suspension of sentence? It will be applicable for convictions under commercial quantity or to intermediate quantity also. That is not very clear to me. Because that means all. That means, yeah, because this aspect is, you have another aspect that 50% of the sentence has been undergone. Otherwise, if you look at it alone, that, after charge sheet only 37 is difficult. And after a full conviction, how can you say that he's not guilty? It is contradictory, actually. So no, 37. So though it has been then, practically there's no suspension of sentence in NDPs. Then that is my query. And second thing, whether it is applicable, because 37 will be applicable in with regard to only intermediate quantity, only that commercial quantity convictions, or to all convictions, because generally it applies only to commercial quantity. So this thing, but he has this other side, this 436. So we'll read that. We'll learn. Okay.